ಏನೇ ಮಾತಾಡಿದ್ರು ಲೈವ್ ಕಳಿಕೆ ಸಾಕಾಗುತ್ತೆ ಸರ್ ಇದು.
ಒಂದು ಚೆಕ್ ಇನ್ನೊಂದು ಅಲ್ಲಿ ಜಿರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಒಂದು
Yes, start.
Number one, Sharat Tisgoda.
I appear for the state in this matter.
Yes, I'm for the petitioner. Here is a company which has been proceeded against under IBP. Now, my lords were pleased to give relief to the extent that the petitioner could challenge. If my lords will kindly have a look at page 380. The order starts at 373. In the petition filed by the state of Karnataka, while setting aside.
What is the matter?
The matter relates to deemed extension of a mining lease
Yes.
Yes, Milord, the matter relates to deemed extension of the mining lease under Section 8, capital A, 6 of the Milord Mines and Minerals Regulation Development Act, Milord, introduced by the Act 10 of 2015. Now, Milord, the last lease that was granted to Defense Barrites Asbestos and Paints
Who are
Limited.
you? Who are you?
Milord, I am one of the directors, Milord, and my lords had granted leave, Milord, because at that time, Milord, the interim resolution professional had preferred an appeal before the NCLT and Milord, an order, a petition before the NCLT, and Milord, that was challenged by the state in a writ petition saying that NCLT had no jurisdiction. Milord, my lords, at page 373.
Where is
Therefore,
authorization in your favor?
pardon me?
Do you have any authorization in your favor?
Yes, Milord. Milord, the authorization is because, Milord, today the company is under IBP. The proceedings are under challenge before the NCLAT. And Milord, I am a person who is the, Milord, if my lords will kindly see, I am the petitioner, Milord, and the one of the directors and shareholders. Milord, kindly see, Milord, page 20, para 2.
What is your grievance? What for you have come here?
Milord, I have come here because, Milord, the deemed extension was not granted, and Milord, I was not even aware of it. The company was given a notice, and Milord, the interim resolution professional under the IBP, IBC, Milord, he represented, and Milord, he has, Milord, the serious allegations have been made by the state of Karnataka alleging fraud and collusion against him by Milord, the state of Karnataka, and Milord, the state of Karnataka was able to set aside the order passed by the NCLT. And Milord, that is the reason why, and Milord, while setting aside the order, kindly have a look at that order, and then I will take my lords through the allegations made by the state against the interim resolution professional also. 373 is the order passed, and at para 9 at page 380, because
This lease was in favor of different parties. Now the writ petition is being filed by the director. There is no authorization.
See, the fraud is going on since 2009. Today they raise. See, sir, before you go further,
yes,
leave of my lord, I want you to please answer one or two questions.
Yes.
If we see your entire case, the lease was in favor of this different varieties.
That's right. That's right.
Your case is that from 2009, some blank papers were taken of the managing director, etc., etc.
That's
from
right.
2009, he has been siphoning off the money.
Yes, ma'am.
All that is happening.
Yes.
The government, there are several irregularities. Government took a view that now we will not do this deemed extension. There was an earlier order. This court division bench said that NCLT had set it aside and that order came here. And now if you want to challenge it, you are one of the directors of the companies.
That's right. I'm a shareholder and director.
That's right. But kindly see from paragraph number 4.
Yes, ma'am.
Right from 2009, you are in knowledge of all this. What is happening?
No, Millard, I can challenge this only, Millard, in 2000, Millard, when the deemed extension was refused. Millard, if my lords will kindly see, deemed extension was refused on 26 September 2018.
Why so, sir? Who must have the grievance? The company must have the grievance.
Yes, Millard, the company unfortunately is now, Millard, is subject to proceedings under IBC. And Millard, there has been a collusion. And Millard, I have challenged that in the NCLAT, the order passed by the NCLT is presently pending in appeal in NCLAT. The company cannot challenge. The company's rights have to be protected by somebody. Millard, therefore, Millard, I as a shareholder and director have come forward. Unfortunately, please see, Millard, what the state itself had to say against the interim resolution professional who was appointed, Millard, by under the IBC proceedings.
Sir, you are not. Sir, your conduct is primarily, you must answer your conduct. From 2009, you know that this money is being squandered, blank papers are being taken. That is your allegation.
Well, I want an opportunity before my extension is refused by the government. I can explain all that. I should have been given a notice. Unfortunately, the company was represented by the very same person who was doing all these fraud. That was a problem. The company never had an opportunity. The shareholders never had an opportunity. Please have a look at
year after year, the annual general body meetings were there, and you see the statutory audit is done of the accounts. You should have attended the meetings. You should have taken stock of situation. Sir, it is too late in the day. It is 1 decade has passed.
No, I am challenging the refusal of extension, which was on 26 September 2018. That is the order that I am challenging, which is
Sir, we are very conscious. We are very conscious of the date you mentioned.
Yes.
At the cost of repetition, we are telling you, please come to page 21, paragraph number 4.
Yes.
Your specific case is that this company is getting into doldrums as far as for more than 1 decade. So no action is taken. All of a sudden today you are coming and as a director you are coming and challenging it.
I was kept out. I was not living in India. I was in Singapore. The problem was this gentleman, we had complete faith in him, and we have come to know now about all that has happened. That is a matter which is being considered by the NCLAT today in regard to the conduct of the whether the company should be wound up, etc. But the company's only assets are the mining lease. And mining lease, the refusal by the government is at page 121. And
you should have got an authorized controller appointed for the company to look after its interest.
Companies under the IBC Act, the person who was appointed has colluded. That is the finding. Please see the Supreme Court order. Please see the Supreme Court order. Please see the Supreme Court order.
You being a director does not mean that you have authority to file a petition on behalf of the company.
Would my lord kindly have a look at page? Otherwise, in respect of an IBC company where the IRP is colluding with some fraudulent person, then the company will go unrepresented. Please see what the Supreme Court had to say at page 367 in regard to the NCLT proceeding.
All of a sudden, after 4 years, now you have awakened and you have come here on behalf of the company.
The government is fully aware that the IRP could not have represented the company because the IRP was colluding. Please see page 367. This is the Supreme Court, and I will show the writ petition. The second question that arises for our consideration is as to whether NCLT is competent to inquire into allegations of fraud, especially in the matter of very initiation of SERP. The question has arisen in view of the stand taken by whom? By the government of Karnataka before the High Court, that they chose to challenge the order of NCLT before the High Court instead of before NCLAT due to fraudulent and collusive manner in which the SERP was initiated by one of the related parties of the corporate debtor themselves. In the writ petition filed by the government of Karnataka before the High Court, it was specifically pleaded that the managing director of corporate debtor entered into agreement on 6/2/2011 with one DP Exports for carrying out mining operation. Said DP Exports was a partnership firm of which one Bhupalan and his wife were partners. That another agreement dated 11/12/2012 was entered into between corporate debtor and the proprietary concerned by the name of PD Enterprises with the very same person. That the said agreement was for hiring of machinery, etc. That there were few communications sent by Bhupalan to various authorities claiming himself to be the authorized signatory of the corporate debtor. That an MOU was entered into on 16/4 between the corporate debtor and Udeman. That the said agreement was purportedly executed at Florida but witnessed at Chennai. That Bhupalan even communicated to Director Department of Mines and Geology as well as also taking up the cost. Now all this goes on.
Whether the company would be able to perform. Then, what is the question of?
I'm sorry. I didn't hear my lord.
This, if suppose the order impugned.
Yes, ma'am.
Which you have challenged.
Yes, ma'am.
Is quashed.
Yes.
Whether the company would be in a position to perform.
Correct. Subject to the orders of the NCLAT, reviving the
Where
company.
is the question of subject to?
No, the problem is, otherwise this is the only asset. There is nothing else in the company. Company, once the company, if I succeed in NCLAT, the company will be
Go
revived.
and first succeed in the NCLT, then come here.
No,
We
then,
will not interfere.
no, in which case, my lords will have to reserve my right. Then that I can challenge it if NCLT, if I succeed in NCLT.
You have no right, mister, without any authorization in your favor.
I am saying I am representing on behalf of the shareholders and directors of the company.
Show from the record.
Please see, I am a shareholder. Please see, page.
Kindly show from the record that you have a right to represent the company. Show from the record.
The problem is I am a shareholder. Then would your lordship do this?
With your problem. Kindly show from record that you are authorized to represent the company.
When the company is under IBC proceeding, then would your lordship give me this? I will
move an appropriate application before.
I will move an application. Would your lordship adjourn this by a week? I will move an application and your lordship may keep it pending.
We will dismiss it at this stage.
No, my lord, your lordship may not dismiss it. Then your lordship may permit me
Because
to withdraw.
You have no right.
Would your lordship permit me to withdraw and move with liberty to move an application for getting an authority to represent the company?
We will not grant you any liberty. We will only dismiss it and withdrawn on your saying. That is all. If you want,
your lordship may record my statement that I will move the NCLAT. Your lordship may not give me the liberty. Your lordship may record my submission and then permit me to withdraw.
All right, take down. What is the other matter?
Lord, I appear, my lord, in that. Can I persuade your lordships to just look at, my lord, the division bench judgment of the Honorable Madras High Court, where, my lord, the shareholders, my lord, have a right to file, my lord, a petition on behalf of the company if the company does not.
So either show Supreme Court or show this High Court. We will not see any other High Court.
Derivative action, my lord, in the company matter, my lord, is a well-known concept. Based on, my lord, the shareholders, my lord, have a right. In fact, my lord, what is challenged is, my lord, the auction notice. There is, my lord, 10 lakh, my lord, 270 crore worth of ore, which has been extracted by the company itself, which is
all right,
there.
we will first pass the order in this first petition, then we will
Yes,
hear you. Take down.
I think the interests are common, my lord. Interests are common. My lords may hear my learned friend also.
Pass order separately.
Right.
Heard Mr. Sarath S. Goda, learned counsel for the petitioner. The writ petition has been filed seeking following relief. After arguing the matter at some length, Mr. Sarath S. Goda, learned counsel for the petitioner, makes a statement at the bar that he intends to move appropriate application before NCLT for permission to represent the company. What company?
Defense Barrites, Asbestos and Paints Limited.
As such, he does not want to press this writ petition at this stage. The writ petition is accordingly dismissed as not pressed. What is your good name?
Vaidyanathan.
Mr. Vaidyanathan. You are assisted by Mr.
That's right. Yes, that's right.
Mr. Vaidyanathan, senior advocate, assisted by Sarath. Makes a statement.
Grateful.
The other matter.
Yes, my lord. What is challenged, my lord, is an auction notice. My lords may come to, my lord, running page 67.
You are also a director?
Lord, I am a shareholder holding 37% shares in the company.
Yes. The other petitioner, the first petition, Are you related to?
No, my lord. Are we related?
Yes, she's the sister-in-law. She's a sister-in-law. Yeah,
I'm told, my lord, that she is the sister-in-law of the petitioner before your lordship.
Yes. It is a family business.
It's a public limited company, my lord.
Public limited is all for the.
My
Yes.
lord, please come to my lord page 67. There's an auction of my lord this company's assets.
Application, I think, tender. Yes. How, what?
Different varieties, my lord, iron ore, my lord, that mine, my lord, is thought to be sold. There is, my lord, can I now persuade? Sorry. Please come to, my lord, page 261, where, my lord, before the Supreme Court, the government itself said,
move under the Companies Act.
please, my lord.
Under the Companies Act, first move an application, move a
But we have
petition.
moved the application. Unfortunately, my lord, what has happened is, company, my lord, because of, my lord, the COVID, my lord, the company law tribunal, my lord, is not functioning. Therefore, we are before your lordship, my lord.
You are a
Any
very,
number of times, my lord, when the, my lord,
you are a
when
very
the,
senior and
sorry.
seasoned lawyer of this court. We need not to remind you that how the writ petition would be maintainable on your
Lord,
behalf.
My lord, can I put it in this manner? Wherever, my lord, there are no functioning of, my lord, a tribunal, we come before your lordships, my lord. Your lordships have been entertaining, my lord, and granting interim orders, my lord, for a limited period.
Is it your case?
Yes, my lord. True, my lord. That is my case. Because what has happened is, admittedly, my lord, there is, my lord, 270 crore worth of ore, my lord, which has been extracted, kept there. In the, my lord, in page 67, not a whisper. And, my lord, that belongs to the company, admittedly. And, my lord, under the mines and mineral, my lord, atomic and, my lord, and hydrocarbon energy. Before, my lord, sale of that, they'll have to issue a notice to the company. They have not issued it.
At page 583, there's a specific query on board that's kept there and they have not answered it. Yes, 370. The board. Yes, sir, 390. Closing stock.
In any case, this has become infectious.
No, my lord.
Notice it was last date was 8th of November 2021.
They have not finalized it, my lord. Therefore, we are before your lordship. But what happened was, we filed the writ petition. Unfortunately, my lord, that had to come before your, my lord, the division bench before my lords. And, my lord, there, my lord, what the last date, my lord, the sitting was not there. Therefore, my lord, it is adjourned. It has come before your lordships today. Admittedly, my lord, your lords may ask the state. They have not finalized, my lord, the auction, my lord. The Assistant Advocate General, my lord, I see him there. The lords may can ask them. They have not finalized it. And before the Supreme Court, my lord, government itself said, yes, there exists 270 crore worth of iron ore, my lord, which has been taken out by the erstwhile company. My lord, the company, my lord, which
now he's saying
306. States after the vote before the Supreme. Article 8.
Only if somebody has taken this land that the company has come.
Asking how it is maintainable, you saying some Madras High Court judgment.
Lord, can I request your lords look at page 263, my lord. Objections filed.
Sir, Holla, sir, we
Sorry. Yes, my
before
lord.
that, yes,
Yes, my
see,
lord.
before that, we had asked some questions to Mr. If you are online, I don't know if you heard, we had
Yes, my
we had
lord.
asked
Can I
questions
request
to
your
Mr.
lords look at, my lord, the division bench judgment of the Honorable, my lord, Madras High Court.
We'll come to
Case
that.
for my lords.
We'll come to that. That's a different
Yes.
matter. The entire case is as follows. The company had taken this property on lease, some 400 and odd acres.
Yes.
Since 2009, company is being handled in a not in prudently according to these two persons, whether the petitioner in this case, petitioner in that
No,
case.
not petitioner has not stated all that. My lord, all that we have
All
said
right.
is
Same, they are the same as my lord was just pointing out. It's a family business. Now today the question is, there have been serious violations of the conditions of the lease. Government has taken it back. Today the auction was in September. Now last date was in November. Today we are in end of January.
auction is not complete, my lord. That is my submission before your lordships. They have not, my lord. They have only, my lord, found out, my lord, the preferred bidders that have not been finalized. And, my lord, can I request your lord, just look at, my lord, page 263. State government's objections before the Supreme Court at page 306.
Fair enough, but what is your locus? You are one of the directors. You are a shareholder.
No,
and
I am a
director.
shareholder holding 37%. What happens is, my lord, can I put it in this manner? If the
If the
company
company is not run in a proper fashion, what is to be done? You must take that action.
Derivative action, my lord, is a well-known concept, my lord, in company law. If the company, my lord, does not take action, my lord, the shareholders have a right to come before the court. That is what we have done now before your lordship.
Under what jurisdiction?
My lord, the derivative action, my lord, is, my lord, the shareholders, my lord,
Whether
represent the
a
company.
shareholder can file a writ petition?
Yes, my lord. Can I request your lordship, just look at, my lord, one judgment which I have placed before your lordships. I have, my lord,
Shareholder
supplied
can
the copy also,
definitely
my
raise
lord.
the issues, but under the appropriate jurisdiction, not under the writ jurisdiction.
Writ only, my lord. That was a case of writ itself. Can I persuade your lordship, just have a look at, my lord, the judgment of the division bench of the Madras High Court. We have placed it for my lord's consideration, my lord.
Madras High Court is not binding on us.
No, my lord. It has a persuasive value. That's all, my lord, I can say, but I understand, my lord. I can never say that it binds your lordships. But it's a division bench judgment. And, my lord, we have relied upon, my lord, a judgment of the Supreme Court.
Where is that
my lord,
page?
sorry, my lord. My apologies.
Page number?
My lord, it's given separately, my lord, with a memo. Only one judgment is given, my lord. Manu TN 0376/2021.
We haven't got a copy. If Narration can give us the names of the parties at least.
It is Naveen Chakravarti versus Punjab National Bank. Manu TN 0376/2021. Can you just email it to AAG?
Yes.
We'll try to email it to your
Sir?
paragraph, my lord, 5 and 6.
No, first show where the maintainability has been considered here.
Naveen Chakravarti.
Kindly show where, in which
Para 7, my lord. 5 and 6, if you are not, please come to my lord 5 and 6. Para 5. However, before such issues addressed, a question of propriety has to be addressed. Since the bank questions the very maintainability of the present proceedings by referring to a Supreme Court judgment reported in 2018 1 year CC. Bank claims that by virtue of such dictum, proceedings cannot be pursued by or at the behest of a corporate debtor while the moratorium is in place, and erstwhile directors or the corporate debtor lose their right to espouse the cost. Erstwhile directors. Notwithstanding the judgment, it does not appear that the right of an erstwhile director as a director of the or right of the shareholder of a corporate debtor who continues to be a shareholder is jeopardized to the extent that an erstwhile director or shareholder of a corporate debtor cannot espouse his cause qua the company by seeking a right to perceive a perceived wrong. There is no doubt that the writ court will be extremely circumspect in entertaining a plea by a director or shareholder of a corporate debtor. But the petition will be maintainable if brought against a statutory authority. Here, my lord, we have filed it, my lord, against the
We
statute.
do not agree to this proposition. Sorry. Sorry. Not on behalf of the shareholder.
Lord, I can only say this, my lord. Derivative action, my lord, is a well-known concept, my lord. There are innumerable judgments. Paragraph 6, middle also, my lord, their lordships, my lord, specifically hold that, my lord, writ petition is maintainable. A writ petition challenging an order by on the ground of jurisdiction may be carried by a shareholder, prejudiced by the same.
There is very limited scope.
Yes, my lord.
Very,
I
very
agree.
limited scope.
I agree
And
with you,
it's
lord. I
not
go
a
down.
fit case. It is not a fit case where a notice is challenged by a shareholder.
My lord, my submission to your lordship is please look at it, my lord. If the company gets up, my lord, wound up, the shareholders, my lord, ultimately, my lord, after their debts are cleared, whatever is, my lord, the balance, shareholders will not get it. 207, my lord, before the Supreme Court, page, my lord, 306. The state itself has said, my lord, there is 270 crore worth of ore, my lord, iron ore belonging to this company. And, my lord, under, my lord, the mineral, my lord, other than atomic and hydrocarbon. Sorry.
Notice, no prejudice. That to a shareholder, what prejudice? Shareholder. Against the notice on this. Proceedings have not been finalized, he himself says.
Not in the atomic, my lord, the minerals and other atomic and hydrocarbon energy mineral concession rules.
Yes.
Any, my lord, iron ore, they'll have to issue notice before sale. In the notice, my lord, they have not even, my lord, brought it to the notice of, my lord, the auction purchasers. 270 crore worth of, my lord, iron ore. Please look at it, my lord, from the public angle also.
What prejudice has been caused to you?
My
You
lord,
are a
I will
shareholder.
get, my lord, if the company, my lord, gets this 270 crore worth of goods, then, my lord, I will, my lord, as a shareholder, my lord, get 37% of it. My right, my lord, admittedly.
You are not company, you are only a shareholder.
I am a shareholder, my lord. Once the company is wound up, I get, my lord, a right therein. Admittedly, my lord.
Well, more appropriate application to protect the interest
Lord,
of
can
the
I, my lord, I
company.
moved the NCLT. Unfortunately, my lord, NCLT is not sitting. That's the problem with COVID. So, my lord, we are before your lordships. Any number of, my lord, times, my lords have interfered when, my lord, the courts, my lord, tribunals are not functioning.
Member is not there or the quorum is
Lord,
not
the
there?
sitting was not there. It was, my lord, the case was there yesterday, my lord, because of COVID. This is the problem, my lord.
No, if because of COVID, the sitting of the court is not
Yes,
there.
my
That
lord,
is
there was
another
none, my
thing.
lord, is what my instructions are, my
But
lord.
if the quorum is not there, then it
Sitting
is a
itself
different.
was not there, my lord. Quorum is not there, sitting is not there because members are afflicted.
Sitting is not there, that cannot be a reason to
That's, my
interfere.
lord. Not only that, my lord, because of COVID, my lord. My lord, please look at this. Today, my lord, we are in a situation where COVID, my lord, is increasing, my lord, by leaps and bounds. Your lordships are aware. Any number of adjournments.
We can
lawyers
only
have taken
observe
before my
that
lords.
you can move an application before the NCLT, which may consider it.
NCLT, my lord, doesn't function. Therefore, we are before your lordships, my lord. If it was
then-
functioning, my lord, I wouldn't have come troubled your lordships. This is all, my lord, I would say.
NCLT तो आएगा नहीं. Then move to Supreme Court.
Lord, I can only go
We
from your
do
lordships,
not
my
have
lord.
supervisory jurisdiction over NCLT.
No, my lord. It has to come before your lordship, my lord. My lords are aware, my lord. From 2000, sorry.
Mr. Hula, the thing is that if the court is not functional,
Yes, my lord.
then High Court can interfere.
Correct, my lord.
The
That is
court
precisely my case.
functional. The only thing is that it is not holding the sitting.
It is not functional in that sense, my lord.
No,
When it is not sitting,
Quorum
it is not
complete.
functional, my lord.
The presiding officers are there. The quorum is complete.
No, my
The
lord.
court is functional. The only thing is because of pandemic, they are not holding the court. that if they are not holding the vote in this, if there is any urgency, you can seek a direction from the apex court, but not from the High Court.
My lord, can I, my lord, request your lordships? Under Article 226, 227, I'll have to move your lordships. That is what the Supreme Court has held.
No,
Time and again, my lord, starting, my lord, from that judgment in 2010.
Kindly show where you have moved the NCLT.
My lord, can I
And
persuade your
NCLT
lordships?
has not taken
Yes.
up your case, and no date has been fixed.
534.
534, my lord, can I persuade your lordships, my lord?
Lord, anyway, supervisory jurisdiction is with Madras High Court. It's not with Karnataka High Court, even if at all, because it is in Madras. It's the NCLT at Madras, not at Bangalore.
My lord, the
It will not come
notifications
under
issued by my
227.
learned friend here.
It
By
will
the
not
state.
come under the 227. NCLT will not come under 227. 520.
My lord, 534, my lord.
In this matter, we have held an NCLT may not have jurisdiction in a sub-field equity action on the filed in IA to Massachusetts. 431.
My lord, before that, can I request your lord just one, my lord, liberty? Please come to my lord 431.
Okay, 470, 45, 01. 417, 45.
I'm sorry, my lord. My lord, the judgment starts at 369, 369,
Yes, what do you want to show?
417, paragraph 45, my lord. This is in respect of this very, my lord, subject matter. Page 417, paragraph 45. Therefore, in fine, our answer to the first question would be, NCLT did not have jurisdiction to entertain an application in the government of Karnataka for a direction to execute supplemental lease deeds for the extension of mining lease. Since NCLT chose to exercise jurisdiction not vested in it in law, High Court was justified in entertaining the writ petition. Therefore, my lord, we will have to come before your lordships only on the basis that NCLT was quorum non judice. Ultimately, my lord, the Honorable Supreme Court held NCLT does not have jurisdiction.
For what?
Therefore, my lord, we have to come before your lordships. We have to move your lordships. Please come to my lord, the next judgment at page 424. Our High Court, my lord, after that said, my lords, my lord, I'll have to move your lordships. Either the company or my lord, the shareholders. Please come to my lord, page 431, bottom 10, paragraph 10. Accordingly, 431. Accordingly, the impugned judgment and order dated so and so of the NCLT are hereby quashed and set aside. Miscellaneous application stands dismissed. As a result of the aforesaid order, government order dated 26th of September 2018 stands revised. That's my lord, the non-my continuance of the lease. As observed earlier, it will be open for the first respondent to challenge the said order by taking recourse remedies available in law. That's a writ petition before my lords. Company can't come, my lord, before your lordships. Therefore, my lord, the derivative action, the shareholders come before your lordships, my lord. This is an order passed, my lord, by your lordships court, my lord, on 20th of January 2020, page 424. And sorry, Supreme Court order at page 422, my lord, if your lordship sees. Supreme Court says, my lord, I have to approach your lordships. Judicial review of administrative action. Paragraph 52, page 422.
Who can approach?
My lord, either, my lord, the company, if the company does not approach, my lord, the shareholder, my lord. That is my submission before my lord.
Where it is not.
My lord, I am fortified by, my lord, the judgment of, my lord, the division bench of the Madras High Court, where their lordships have held derivative action, my lord. In fact, my lord, it is not just one judgment. There are innumerable judgments where, my lord, shareholders, my lord, represent the company and file a petition. If the company does not do its action.
Under the Companies Act,
Yes, my lord.
not under the writ jurisdiction.
No, my lord. Under
Yes.
the writ jurisdiction, that's what, my lord, I read to your lordship, my lord, this division
So
bench
that
of the
is
Madras High
only
Court.
one judgment you have shown, that is Madras High Court, that we, with all respect, we say that we do not agree to that.
My lord, I'm in your lordship's hand, my lord. Can I say anything more, my lord? I can only say this. Please look at page 423. Honorable Supreme Court has held judicial review of administrative action, my lord, is what is. NCLT passed an order that was set aside by the Supreme Court. And, my lord, the Supreme Court held judicial review is maintainable. Therefore, my lord, I read before your lordships.
Asked NCLT to direct the RP to file, which he is not filed. So I filed.
We moved the, my lord, NCLT.
Where you have moved the NCLT, you have shown it, where is that?
My lord, please come to running page 534, my lord.
534. Kindly show from this that you have moved against this to protect the interest against this notice.
Lord, can I persuade a lot come to paragraph Lord A? Direct the respondent to take recourse to the appropriate remedy under section 30 of the Mines and Mineral Development and Regulation Act in respect of illegal, arbitrary, non-renewal of the mining lease. Direct the respondent to take appropriate steps to take custody of so and so. Such other directions. And my affidavit, my lord, is at the next page.
Please.
Sorry, my lord. My apologies.
We want to understand against this impugned notice.
Yes,
You have approached the NCLT.
No, my lord. Not against that impugned notice. I can't.
Then
My lord, I can't, my lord.
you said that
Because-
you approached the NCLT since it is not holding the court due to pandemic. Therefore, you have come here. This is
My
what
lord,
you are.
can I, sorry, my apologies. What I moved was, my lord, in relation to, my lord, the non-renewal of the lease.
Please.
That I moved.
That is not with respect to the impugned notice.
Correct, my lord. Impugned
Yes.
notice, I can only move your lordships because
Oh, sorry.
of the Supreme Court order, which has held that, my lord, I can't, my lord, nobody can, my lord, approach the NCLT for, my lord, under the Mines and Mineral Regulation Act.
No, it is not so. It is not so.
My lord, can I request your lordships again have a look at, my lord,
Yes, page
405.
47. That page 47, 45, which you showed,
Yes, my lord.
was with respect to entertain an application against Government of Karnataka for direction to execute supplementary lease deed.
My lord, can I put it in this manner?
No,
What happened was, sorry.
We need not to tell you what are these. At least it is not expected from you that you will argue in this manner. That whatever was held by the apex court was in respect of something very different, not with respect to the mining lease that you cannot approach the NCLT.
My lord, can I, my lord, if I have not, my lord, read the whole of it because it is too lengthy, can I request your lordship, just have a look at, my lord, one paragraph. Then, my lord, I will not trouble your lordships anymore.
Yes.
Please come to, my lord. My lord, page 371. What are the facts?
Page 371.
Please come to 3. At the time, the corporate debtor held a mining lease granted by the government of Karnataka, which was to expire on 25/5/2018. Though a notice of premature termination of the lease had already been issued on 9/8/2017 on the allegation of violation of statutory rules and the terms and conditions of the lease deed, no order of termination had been passed till the date of intimation of the corporate insolvency resolution process. Therefore, interim resolution professional was appointed by NCLT. Addressed a letter dated so and so to the chairman of the monitoring committee as well as the director of mines and geology, informing them of the commencement of CIRP, that is, my lord, corporate insolvency resolution process. He wrote a letter to the director of mines seeking the benefit of deemed extension of the lease.
Yes.
Beyond 25/5/2018 up to 31/3/2020 in terms of 8A of the Mines and Mineral Development and Regulation Act of 1957. Finding that there was no response, interim resolution professional filed a writ petition on the file of this honorable court for a declaration that, my lord, the mining lease should be valid up to 31/3/2020. Then, my lord, an NCLT petition was moved. My lords get that, my lord, at page 273 bottom. 373 bottom, 373 bottom, sorry. 9. By an order dated 11/12/2018, NCLT Chennai allowed the miscellaneous application, setting aside the order of the government of Karnataka on the ground that the same was in violation of the moratorium declared on 12/3/2018 in terms of section 14(1) of the IBC, Insolvency and Bankruptcy Code. Consequently, tribunal directed the government of Karnataka to execute supplemental lease deed in favor of the corporate debtor for a period up to 31/3/2020. Aggrieved by the order of NCLT Chennai, government of Karnataka moved a writ petition before the High Court of Karnataka. When the writ petition came up for hearing, it was conceded by the resolution professionals before the High Court that the order of NCLT could be set aside, matter relegated to the tribunal for decision on merits. Therefore, my lord, that order was set aside. Ultimately, my lord, NCLT, my lord, passed an order 375.
What we are saying to you is
Yes, my
that
lord.
want to protect the interest of the company against this impugned notice,
Yes,
then
my lord.
you can move to the NCLT.
My lord, if your lordship will not give that permission, my lord, I'll again, my lord, approach them, my lord.
You being the shareholder, no, there is no need for us to give permission or not permission. You being the shareholder, if you want to protect the interest of the company, then you can move before the NCLT where the matter is pending. Writ petition for that purpose would not be maintainable. This is what our prima facie view is.
Because only thing was, my lord, Supreme Court held that, my lord, the matter, my lord, judicial review is the only action, my lord, that is available to us. Either the company or shareholders. Page, my lord, 423. 22 and 23, your lordship saw, my lord, that.
NCLT didn't have jurisdiction in this very matter. This very matter.
Para 52, my lord. NCLT and NCLAT would not have jurisdiction to adjudicate upon the disputes such as arising under the MMDR Act, that's the Mines and Mineral Development and Regulation Act, and the rules issued thereunder. And it can be corrected only by a judicial review of administrative action before my lords.
Yes.
Therefore, my lord, I am before your lordship, my lord. I can't go before NCLT.
Oh, it is not with respect to the dispute regarding MMDR Act. It is with respect to protecting the interest of the company. Therefore, we are saying that you go before the NCLT.
My lord.
NCLT cannot decide the dispute arising out of MMDR Act.
This is a dispute in the India.
Sorry, my lord, I didn't get your lordship.
NCLT cannot decide any dispute arising out of MMDR Act. Correct.
This
is the proposition which has been laid down. We totally agree to that. We do not dispute that. The only thing is that you want to protect the interest of the company as a shareholder. So, at the most, you can raise the issue before the NCLT.
My lord, I cannot, my lord, please look at it. Auction notice at page 67. Question is, my lord, whether that auction notice is correct, valid or not. That, my lord, the NCLT can't, my lord, examine it. Only, my lords can examine it. 270 crore worth of, my lord, the iron ore, my lord, not even mentioned there. Please look at it. Public interest, apart from my interest. Page 67, not a whisper. And their own, my lord, statement before the Supreme Court was in this very matter that, my lord, there is iron ore worth 270 crore worth, my lord, iron ore which has been extracted from the mine and, my lord, kept there.
At the most, if you want, we can give you liberty to approach.
As your lordship, please, my lord. I'll be, my lord, I'm grateful to your lordship, my lord. Please, my lord.
Yes. What do you say, Mr. Chinnappa?
My lord, I have two submissions to make. There is already a petition pending before the Honorable Supreme Court challenging, my lord, both this auction as well as asking for an extension of the mining lease filed, my lord, by the resolution applicant. What has now happened and what is not being told to your lordships is this entire CIRP, that is Corporate Insolvency Resolution process under the IBC, has been completed. And thereafter, a resolution applicant has practically taken over the company. That's a company called Embassy Property Development Private Limited or Limited. They, my lord, have filed, as a matter of two things have been done. Against the order refusing to grant extension of the lease, they filed a revision application before the central government. It was rejected. Therefore, the company went, my lord, to the revisional authority and challenged it. That they did not disclose before your lordships. Then Embassy Property Development, which is the successful resolution applicant, has filed a 32 petition in the Supreme Court, and the Supreme Court has permitted us to continue with the auction, saying that the announcement of the successful bidder will be done provisionally. Now, when that is almost at the very end, two other parties come before your lordships and file a writ petition before your lordships saying stall the auction. I asked myself, Lord, this is nothing but a classic case of using different fora at different points in time by different people to achieve an objective, namely to stop the entire auction process. Supreme Court has said, I've sent, my lord, along with the memo, the order of the Honorable Supreme Court. If your lordships may kindly ask for the memo, my lord. The court officer has the memo.
We have not been given. Copy has not been
sent,
given.
my lord. It's been sent to everybody.
When? We did not receive it. Yes.
When did you send it?
Gone to the office
Is
now.
there any memo? The court officer has not received.
Yeah, nobody has
It has been
received.
given, court officer has been given a memo last time. On the last date of hearing, the court officer was given a memo.
Sitting was cancelled, my lord.
Eh?
Sitting was cancelled.
Yes, but
And
I
nobody
was
was
sent a
given.
memo.
We were not given
19/1/2022. May I just read the order of the Supreme Court? I'll just read. It's a 2-line order. This is filed by the successful resolution applicant before the Supreme Court, saying that the lease period should be extended by 58 months. That is the prayer. The Supreme Court said the auction, if any, may be completed provisionally and shall not be finalized without leave of the court. So at best, they can only approach the Supreme Court in that writ petition. They cannot, will not come here or go to the NCLT.
Either approach the NCLT or this. Who has filed this 32 petition?
This is, my lord, filed by one Embassy Property Development. I think it is the respondent number 4 before your lordships. No, my lord, they're not a party. I'm sorry, my lord. They're not a party here.
They are not parties. We don't know who they are.
I'm sorry. They're not. Lord, they are the resolution applicant. I don't know why my friend saying we don't know who they are, because they have challenged that order before the NCLAT, and the NCLAT has passed an order that the resolution plan shall proceed at the risk of Embassy Property Development. So today the resolution plan is proceeding on the one hand. Embassy Property Development files a writ petition before the Supreme Court saying that the period of mining lease when mining operations could not be carried out should be extended. That is pending there. Two other people claiming to be shareholders come before your lordships, my lord, making different prayers, practically asking the same reliefs. Saying, anyways, stall the auction. In any event, this auction, my lord, has to be ultimately finalized with the leave of the Supreme Court.
Yes, yes. Previous petition.
Mr. Hula, you will have to approach the Supreme Court only.
Lord, as your lordship pleases, my lord. I am in your lordship's hands. I did not know about this, my lord. I did not know about this. They did not even give me a copy. Doesn't matter, my lord. I am in your lordship's hands, my lord.
Yes. Heard? Mr. Hula, senior advocate, assisted by such and such for the petitioner, as well as Mr. Dhyan Chinnappa, additional government advocate general, for the respondent number 1 and 2. The writ petition has been filed seeking following relief. Mr. Dhyan Chinnappa, additional government advocate general, appearing for first and second respondent, has raised primary objections regarding maintainability of the writ petition on the ground that the resolution applicant Embassy. Yeah. What is the name of company? Embassy, Messrs. Embassy Property Developments Private Limited, Bengaluru, has approached the Supreme Court by filing writ petition under Article 32 of the Constitution of India regarding what? Seeking. No, you are not audible. Please unmute yourself.
You are muted.
Extension of the mining lease period of 50
For extension of the mining lease
period
and
by 57 months.
period by 57 months,
57 months.
being the
Successful resolution applicant of this company
successful resolution applicant
of Tiffin
The-
Barrites.
of the company Tiffin Barrites. The Honorable Apex Court has passed the order dated
My lord, 8/6/2020.
8/6/2020, providing therein that
The auction, I'm sorry.
yes,
I'm sorry,
auction
Lords. Auction may be completed provisionally and shall not be finalized without leave of the Supreme Court.
Note down. It is submitted that the matter is seized with the Apex Court, and as such, the present writ petition is not maintainable. Learned counsel for the petitioner try to submit that the petitioner, being the shareholder, has a right to protect the interest of the petitioner, and as such has filed the instant writ petition challenging the impugned notice. Full stop. We have considered the submissions and gone through the record. We are of the considered view that once the matter is pending before the Apex Court, it would be appropriate that the petitioner, if feel aggrieved, may move appropriate application before the Apex Court. And in the present facts and circumstances, the writ petition is not maintainable. The writ petition is accordingly dismissed.
I'm grateful.
Grateful, my lord. My lord, had I known this, my lord, had my learned friend given it to me earlier, I would have myself considered. I'm sorry. I owe an
That is
apology,
why
my lord.
we did not pass a detailed order. We just cut short.
Please, my lord. Grateful to your lordship, my lord.
Number 2.
Yes.
Saravana.
Happy for the statement.
My lord, I got one submission, my lord.
Yes.
My name is shown as representing the respondent number 3. It is Cooperative Election Authority. I no
Yes.
more represent my because I have resigned.
All right.
That's what I wanted to tell before this honorable court.
All right.
My lord, I represent the Cooperative Election Authority. My lord, my name is Kiran Kumar TL. My lord.
Anybody represents the petitioner?
In some of the writ petitions, I am representing.
Give the file.
My lord, in serial number 24679, my name is shown, my lord.
The elections are over. Elections have been held.
I'm not aware, my lord, because I am no more representing them. Since a long time, I have resigned, my lord. I am not aware of it.
What we propose to do is that we will, since the elections are over, we will hold that the question so far as validity of these sections is concerned, that is left open to be considered in some other matter. And the writ petition.
In single case, 5 out of 24 and 25. upheld already. Many just
So
because
this,
एक क्यों है सर क्योंकि बीच में DB को ड्रॉ हुआ. That is why these matters have come.
okay. Well, my brother informs that the validity of section 20, subsection 2, which is under challenge in this writ petition, has already been considered by this court and upheld. Now this petition has become infructuous.
Yes, my lord.
Yes, my lord. All these matters, my lord, which
They
is
have become infructuous.
yes,
Yes, ma'am.
My lord, serial number 50, my lord.
Just wait, mister. Wait. The writ petition has been filed challenging the validity of section 20, subsection 2, in bracket small a dash Roman 4, bracket close, then again bracket small a dash 5, bracket close, Karnataka Cooperative Societies Act. The validity of this section has already been upheld by the judgment of this court. Give the detail, take the detail and write it.
I'll give it.
In WP number 48973 of 2019, my lord, and connected matters.
Write the details, take out from the computer and write the details.
His Lordship P.S. Dinesh Kumar has passed.
It is also informed that the elections have already been held. Election of the petitioner society has already been held. In view of above, the writ petition has become infructuous. It is accordingly dismissed as infructuous. Now,
Much obliged.
anyone who says that his case is different from what we have taken note of and for which we have passed the order, then he may inform the court.
May I make one submission, your lordships? In
Yes.
serial number 53, it has become infructuous, but the name of Mohammed Tahir is being reflected in the cause list, but he has not filed the wakalat, your lordships.
Serial number 53,
Doesn't make a
I
difference.
appear for the contesting respondents. It has not become infructuous, my lord. This is slightly different. Serial number 53.
Take out the file of 53.
my lord, one indulgence,
In
my
all
lord.
this order will be passed in all the matters except those whom I will tell you.
All these petitions, my lord, his lordship has, my lord, disposed of the by upholding the constitutional validity of this section. My lord, his lordship has safeguarded the interest, my lord, whichever the elections have already been over. That would not come in the way.
Already.
That's what my lordship has safeguarded the interest of the petitioners. Your lordship may kindly say, my lord, in terms of the order passed by his lordship, my lord, these writ petitions are disposed of.
Single list order, division by another. All right, we'll see that judgment. Then we will modify this order. What
Please.
Lords,
Yes.
serial number 75, my lords.
Just one by one. 53.
Serial number 53.
Yes.
In this case, my lord,
What is under challenge?
my lord, certain petitioners approached the honorable court, sought for election rights, and my lord, rights were given, challenging the validity of the act.
What is the main prayer, Mr.
My lord, I am for the contesting respondents. I wish to say the prayer is same as it in other cases, my lord. In all these
Then what do you want now?
My lord, in this case, what happened was some dead persons also came before the honorable court.
Oh yes, that.
Please, that's what your lordship heard me. Therefore, this slightly different.
Mr. Hegde, you are a senior advocate. Leave it off. Those are matters which have.
No. Only for this reason, my lord. Once the constitutional validity is upheld. Number two, the interim orders obtained by fraud are necessarily required to be recorded.
File a case of perjury.
We have filed applications for those applications are pending before this, my lords. In this case.
Forget, we are dismissing the petitions as infructuous.
No, my lords, once your lordship may kindly see this, in this case, it's a very serious matter for this reason.
Mr. Hegde, just hold on. You can say that. Section 2. See, Mr. Hegde, if anybody.
Not say anything. Let them do whatever they think. If you want to file a complaint, go and file a complaint.
No. Please.
Lodge a case for perjury.
My lord, may
file a FIR, whatever you want.
My lord, may I submit, my lord? Please bear with me for a moment for this reason. My lord, identical circumstances where some person approaches this honorable court, my lord, and obtains an interim order, and then, my lord, an election is held. Where that election should be challenged is one question, my lord. This question, my lord, I have produced those citations, my lord. The Honorable Supreme Court has considered and laid down, and it is only the High Court which has to consider, not any other court. And may I beg to draw my lord's kind attention to those decisions, my lord. 90 in the list of citations which I have produced. I'm sorry, only one set has been produced today.
What for you want to cite all this?
In 1993, my lord, identical circumstance.
Sorry, we will not pass a different order. We are passing the same
your
order.
lordship, in the present case, your lordship, once the constitutional validity is upheld,
yes,
these persons have obtained the order stating that constitutionally it is invalid, my lord. Therefore, we want the voting rights. Based on the voting rights, they exercise the votes. And the interim order itself is granted, my lord, holding that this is subject to the outcome of the writ petition.
Now the writ petition is dismissed.
Dismissed, the interim order should be automatically vacated. Those who have enjoyed the benefits of the interim order, they cannot continue those benefits, my lord.
Go and take action against them.
No, that's another aspect, my lord. Now this honorable court granted an interim order, and that interim order, two things. One, obtained on the ground that's constitutionally invalid and subject to the result. That's the interim order is vacated now automatically. Secondly, in the present case, the interim order is obtained by making certain false representations. 2 points. Therefore, my lord, the interim order is also liable to be whoever has got the benefit of the interim order, my lord.
All right, we will give you liberty to just take
your lordship
appropriate.
Kindly hear this. I will produce two sets. As far as this case is concerned, my lord, it's entirely different than other cases. The only one set is produced today. I'm extremely sorry, my lord. Excuse me, because we did not know. One set is produced. We will produce a second set. My lord may hear. For this reason, my lord, these are covered by the decisions of the Honorable Supreme Court.
All right. We'll pass the same order. In addition to this, say that the counsel for petitioner submits that the interim order was obtained by fraud and misrepresentation. If that is so, the petitioner has liberty to initiate appropriate proceedings before
my lord, I'm extremely sorry. I made to make one submission.
Court.
Please bear with me for a moment, please. Those applications are pending before my lords.
Who are alleged to have obtained the interim order by fraud.
My lord, those applications, kindly bear with me, my lord. Once this Honorable Court has passed an order, I have filed application before this Honorable Court. This is what Supreme Court observes. I cannot go to any other court when the writ court has passed an order. No other court can sit and decide what is the effect. May I read one sentence?
We are giving you liberty, no? We are giving you liberty now. We are giving you liberty.
My lords, liberty cannot be.
We are not going to initiate any proceedings.
You are not may kindly decide, my lord. One sentence, my lords, may kindly be pleased to permit me to read one sentence of what the Honorable Supreme Court has laid down.
Yes.
1993, Volume 4, SEC 216. Exactly same situation. Election was held, my lord, and then the matter went to they obtained the interim order by playing certain fraud, etc. Then the contention was, now the election is over. And this question was concerned Ramchandra G. Shinde. I produced that order, my lord. And then the Honorable Supreme Court, when the order of the court issued under so and so, under Article so and so, is the foundation for the election. And if the order is initiated by an error of law,
is it your case
has no
that the elections have been held under the direction of the court?
Please, my lord, this Honorable Court granted the permission for these voters to conduct, to vote hundreds of persons.
Mr. Hegde.
Honorable Supreme Court says
Mr. PP
that
Hegde
cannot be impugned in an election petition. And it's only the Honorable High Court which can decide. That cannot be done, my lords. With great respect, my lords, Since entire voting process, my lord, hundreds of voters have got the voting rights based on the interim orders. It is only this honorable court that can decide this question. And to dead persons filed application, your lord, what's the effect on the admission justice? Dead persons, about 30 to 40 dead persons filed application.
Lordship, name of Mohammed Tahir may be deleted, your lordships. He has not filed the wakalat. Lordships, in the previous matter,
My lord, whether my prayer is, my lord, your lordship is kindly consider my prayer, my lord.
Still pass the order, Mr. Hegde.
Your lordships, the name of Mohammed Tahir may be deleted, your lordships. He has not filed the wakalat.
With all great respect, my lord, make one prayer, my lord. The interim order may kindly be vacated in view of this, my lords, because nobody can continue with the benefit of the interim order once. My lords, hold the constitutional validity, my lord.
The interim order stand discharged.
Name of Mohammed Tahir may be deleted. He has not filed the wakalat for the petitioners. By mistake, the name of Mohammed Tahir has been shown in the cause list, your lordships.
We have decided the matter. We will discuss it.
Please.
Lord, my lord, kindly, my lord, serial number 76.
Where the act is challenged. Item 63 onwards. 63 to 71. Where the act is challenged. Item 63 onwards. Till 71.
Up to 62, this order will stand.
Up to 62, serial number 62. This order which we have passed is up to serial number 62. What is 63?
63.
Why it is clubbed in this? Why it is clubbed in this bunch?
These are all different matters, your lordships.
63 onward, they are different matters. Huh?
No, cooperative society also is there.
Yes, classification is there.
Yes.
It is in relation to the validity has been questioned by the cooperative societies because the provisions of the RERA Act, according to them, Lord, is not applicable to the development of flats by farming layouts, Lord. So therefore, it is under the Cooperative Societies Act.
It is different issue, no?
Its issue is different, Lord. Your lordships may have to decide it. There is a judgment of the Bombay High Court, Lord, and in few of the matters, state has already filed statement of objections.
List them separately.
Please.
63 up to 60, from 63 to 71.
Please.
My lord, even 71 is also the provisions of RERA Act is challenged insofar as it is applicable.
It will be listed again. Yes. From 63 up to 71 would be listed again.
Yes, ma'am.
Right, and this under challenge is the provisions of RERA Act. The matter requires consideration. List on date, give it date. After 1 month. And now this 72. Same.
My lord, serial number 72, my lord, appearing for the petitioner.
What is the matter?
My lord, we're challenging section 16 clause 4, my lord, of the same act, my lords. My lords, in the last occasion, my lord, a similar matter, my lords had disposed it of, my lord, reserving us liberty. My lord, reserving us liberty, my lord, to challenge any consequential order passed, my lord, in a similar matter.
All right. In this case also, you are no consequent. You are not challenged consequential
No,
order.
my lord, we have not. No, my lord. My lords may reserve us liberty to challenge any other order, my lord. In the
Yes. Your good name, please.
Archita Suresh, my lord.
Srimati so-and-so, learned advocate for the petitioner, submits that petitioner has challenged the virus of section so-and-so, so-and-so. However, no consequential order passed under the said provision of law is challenged. It seeks liberty to. You want to withdraw or dismiss it as a not pressed?
My lord, disposed with liberty, my lords, to
Okay,
challenge
and
any other
seeks liberty
consequence.
to challenge any consequential order if passed in any time in future. Full stop. In view of the above, these petitions are disposed of, reserving liberty to challenge the consequential order as also the queries to the sections challenged in these writ petitions.
Grateful,
Yes.
my lords.
This order would be passed in 72 and 72.1. Now 73.
Grateful, my lords.
But 73, Lord, elections have apparently Lord, been held. Prayer was for direction to Lord, conduct elections. This has become infructuous, Lord.
Right 73, Learned AGA, appearing for respondent informed that elections have already been held and as such writ petition has become infructuous.
Please.
The writ petition is accordingly dismissed as infructuous.
Obliged.
But so far as 74 is concerned, my lord, we have not challenged any virus of the any act, my lord. It has to go before the learner single judgment.
Section 29E.
No, you are not challenged any virus of the act, my lord.
Take out the file.
We have sought for, my lord, only declare that the act of the respondent number 3 is ultra virus to the section 1929E. Prayer B. Action. Yes, yes.
Some confusion because of your prayer.
Please, me, please.
Act cannot be ultra virus.
Yeah, act. No, the act of the respondent number 3.
It cannot be ultra virus. It can be contrary to the provision.
It might be some employing language in the prayer.
Foreign language.
Sorry, Miller, sorry. It has to go before the learner single judgment.
Learner counsel for petitioner informed that he has not challenged any virus or any provision of law, and as such, the matter is cognizable by learner single judge. Office may verify and this before appropriate court at an early date.
Deeply opens.
Serial number 75, my lords. Challenging the section 18, my lords.
Yes.
Of cooperative societies, my lords.
Yes.
Lords, the petitioner membership has been seized. And section 18, my lords. That has been challenged, my lords.
No, which communication you have challenged?
My lords, annexure F, my lords.
That is based on 18B1, is it?
Please, my lords, please, my
Learned counsel for petitioner submit that this petition has not become infructuous. No, para. The statement of objection has not been filed.
Second.
The respondent may file the statement of objection. Para. The petitioner undertakes to provide the second set of writ petition. List. Give a date. After 1 month.
March.
Next.
Interim order may extend it.
Is there any interim order?
Please, my lords.
Lord, I oppose interim order. Lord, Lords may kindly appreciate, Lord, I have instructions to state that an administrator has been appointed and Lord, the elections have also been conducted subsequently. I'll Lord file statement within a week's time. The Lords may kindly dispose of Lord. the writ petition immediately thereafter.
My lords, I have challenging the annexure F, my lords. Now I am the director of the respondent number 4, Chamarajanagar District Cooperative Milk Producers, my lords. Now the election held in the respondent number 3, my lords.
Madam, see, let Madam complete her instructions and then come file an appropriate memo or something. Then we'll take it further.
Please, my lord. Your lordship may kindly have it on Friday or Monday, my lord. I'm sorry, subject to your lordship's convenience.
Already decided, give the date.
76 ka nahi, 75.
Lord 76, my lord, I appear for the petitioner, my lord. Here in this writ petition, we have not challenged the virus of any of the provisions of the Karnataka Cooperative Societies Act. And it was actually listed before the learned single judge who considered the matter and granted an interim order. Lord, it is only the prayer is that our request to the election officer was to conduct the election only to the vacant post.
Learned Counsel for Petitioner informs that he has not challenged the virus of any provision of any act of the Cooperative Society Act, and as such, the matter is cognizable by the single judge. The office shall verify and this before appropriate court at an early date.
Lord, the interim order granted is extended till today.
Interim order value shall continue till next day.
Grateful, grateful.